waiting for the next surprise. Skeleton Jack might catch you in the back as she make you jump out of your skin. This is Halloween, everybody scream. Please make way for a very special time. Our man Jack is king of the pumpkin patch. Everyone hail to the pumpkin king. Now this is Halloween, this is Halloween, 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 Halloween. That's our job,
But we're not mean.
in our town of Halloween.
In this town we call home. Everyone hail to the pumpkin song.
It is Artie's Corporate Fiction. Welcome, everybody. Glad to have you with me. We are going to take a look at the latest shenanigans going from the Darrell Brooks trial. Hopefully, but I also wanted to go a little bit deeper into a lot of questions that people have been asking ever since this mess began, starting with when the judge granted him his right to proceed without an attorney. As you may have imagined, in the last 48 hours, I should say, the Mr. Brooks has made a mockery of the process with his antics. So what we're going to do is we're going to take a look at why did ultimately we're going to answer the question, why did the judge grant this for him. But we are going to watch a couple of the highlights from today's proceedings, a couple of videos that I was able to get. The reason why we're not able to live stream it is because the judge explicitly forbade live streaming the proceedings while jury selection was ongoing. So that's the reason why we're only getting clips here and there and not a full recap. So with that said, I don't know the problem. Unfortunately, I don't know whether or not these are in chronological order, like these events. I tried to, but I'm not sure. But this one's probably the one that's going to piss people off the most. It kind of pissed me off the most. But this is after the judge had already moved into the other courtroom, and the judge is putting things on the record here.
Indication that he can hear this court. I've also confirmed with the bailiff and court staff that he's able to see and hear. So with that, unless there's anything the state wishes.
So again, very short clip there with the way he's acting.
That myself, the attorneys in this courtroom, the litigants, it even applies, as you can see if you read it, applies to witnesses, jurors, those in attendance. Everyone here has been respectful other than you throughout these proceedings.
I object to that respectfully. I have not been disruptive, and I do not see any paperwork that you just described to be in front of.
So that was another one. Now we're going to go to what was recently uploaded. This one's more of closer to a recap of what's been going on of the proceedings.
Thank you. This time I have my phone so I can call Darlene and have her let my pups out. Yeah. It was a fatal mistake. I know, which I couldn't contact her to say it's going late because I put my phone downstairs.
So the judge would like you to cross off any people that are already named in number 8.
Oh, yeah.
Okay, that'll be.
And then, and when you, she's talking to Catherine.
Okay.
And then anyone you know you're not gonna call.
Okay, okay,
And then she is gonna do that.
okay.
Oh, perfect.
But I should do it here. Okay.
All right, we are back on the record. Mr. Brooks, I was able to inquire. I've been told it would take maybe 15 minutes, but I'd like you to go to your cell to get whatever that list is that you have so that I can adequately advise the jury, potential jurors, about any witnesses who may be called in this case. I don't designate when I say if it's the state or the defendant, but you told me you have that, so I'm going to give you that opportunity. In the meantime, I'm going to print off the state's witness list
I don't need it.
and give them to the state so that you can cross out any individuals who are already listed in question 89.
We have that already, and we just started doing that.
All right. And then what I plan on doing is once I finish with all of the questions and the follow-up of
Thank you,
this
Carl, for the
group,
$5.
I will bring, and then we'll discuss if there are any additional strikes for cause, okay? Once I get through that, I'm going to bring in all of the jurors. So I'm going to do an audible. We'll have to, I know the press has been here. You'll probably have to be in one back row together. There is the press room, the jury assembly room, if there's not enough room. There are, and we'll just figure it out from there. But I'm not closing the courtroom by any stretch of the imagination, but I need to, that's a long witness list. I need to make sure none of these jurors know any of these individuals, either personally or by reputation, work with any of them. But we should be able to do that, still maintain some room for victims, some room for the press, and we'll go from there.
And Your Honor, just one other quick thing. I know that you asked the defendant if he had any questions that he wanted you to ask. I would just, the issue that he's brought up with being deaf in one ear, I'd also ask if he has any questions of yesterday's panel that maybe he's unclear or didn't hear anything, although he didn't notify anyone he was having trouble hearing. He was answering questions in the other room without the headphones on. Actually, he was given the headphones. It took him a minute before he even thought to put them on. But just to see also if he has any questions, obviously he's got to follow the Supreme Court rules, but if he wants to ask the jurors any questions, either from yesterday's panel or today's panel, any concerns that he may have about any of them.
I would agree that that's a good procedure to employ, Mr. Brooks, so you'll be given that opportunity. I would note he does not have the headset on here. I can make a further record that previously especially when I went through the waiver of right to an attorney, I realized that was in this courtroom, but he at times would answer, I hear you, or I heard you.
Thank you. Thank you for the $5.
And, but Mr. Brooks, you're advised that if there are any follow-up questions on anything you didn't understand or you believe you didn't hear, we will have all of the jurors at one point that are remaining from yesterday and today brought in the courtroom. All of them have numbers, and you'll be able to do follow-up that is appropriate. Now, you also mentioned previously when I referenced going back to your cell to get the list. I'm giving you that opportunity. You asked me to do that.
I did not ask you to do that. The question was, where was the list at?
That's true. So you said the list was in your cell.
What they're talking about here is that they're talking about the And I think Danny just pointed out that I completely missed a different video, so we're gonna watch that different video from the beginning. But what happened is, what we're dealing with now is jury selection, and part of jury selection is that both parties, the state and the defense, have a list of witnesses that they're going to bring to trial. The judge is talking about his witness list that apparently that he left at his cell. The judge is saying, I'm going to give you the opportunity to go back to your cell, get your list so that you can present it to the jury, or so that it can be given to the court, so that the court can read out the names of the witnesses, so that the jurors can notify the court whether or not they know any of these witnesses. So that's part of what they're talking about here. But Mr. Brooks now says that he doesn't want to go to his jail and get it.
I'm advising you that I'll give you the opportunity
I
to
don't want
go.
to do that.
Can I finish? I'm advising you that you are being given the opportunity, if you so choose, to go back to your cell to obtain the list of witnesses that you have been working on. Further advising you that if you choose not to do that, your one option would be to verbally tell the court any additional names to what you've already provided. Write those down for the court, so that either tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
So now you kind of hear how he's trying to play games. He knows that the list is at the cell. The judge just said that I'm going to give you the opportunity to get the list. But now he's all talking about, well, I don't have a list in front of me. How am I going to do this?
The list that you have in your cell?
How am I supposed to do that without the
I'm
list?
telling you, I'm giving you the opportunity to go get that.
I'm not
So,
going to go do that.
Mr.
And now he says, I'm not going to go do that. Again, now this is with the sole purpose of he's actively frustrating the process.
Brooks, I'm not going to play games with you.
And
I'm giving you an
not gonna-
opportunity.
and I told you that
You
I'm
either
not
go to
gonna
your
do that.
cell and
You
get
said
the
I have the
list or
opportunity
not.
to do that.
All
You
right.
said I have the opportunity.
I'm not going to demand that
do
you do it, but you have to understand, sir, that if you
I
choose
don't
not to
understand.
do that.
I don't understand. I don't understand.
All right,
I've
Mr.
made
Brooks.
that clear. I don't
You
know how
claim
many
to not
times for the
understand,
record.
and that's been made very clear
I don't
here,
understand.
sir.
You're not going to get me to consent to something that I don't consent to or agree to. I do
know.
not
All right.
understand. Just
Mr.
like I
Brooks,
don't
we're gonna
understand the
take a
nature and
recess
cause
so
of
that
this.
the court can get this
exactly
information
like I've
from
been
the
telling you
state.
from the beginning.
Okay, he's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned. Once again, if you continue with that, you will be removed from the courtroom.
Remove me.
Requesting to go to the other
Remove
courtroom?
me. I told you that before I even came over here.
Sir, are you requesting to
I
go?
told you that before I even came over here.
Mr. Brooks, are you
That
requesting?
It was pointless of me to come over here. You can smile all you want and think
Sir,
it's funny. I don't take this as a
preference-
joke. I don't take this as a game.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet
Right.
to verify anything
You
by
can take
sworn
him back to
affidavit.
the other room.
You
He's
haven't
been
even honored-
disruptive.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies
You
and
haven't even
gentlemen. We'll
honored-
have to
you haven't even
clear
done
the
that.
courtroom.
I got any-
Wait, what did you just say about his appeal? I think I missed that part.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you. You have yet
Right.
to verify anything
You
by
can take
sworn
him back to
affidavit.
the other room.
You haven't
He's been
even honored-
disruptive.
You haven't even honored my request to make an offer for my appeal.
Thank you, ladies
You
and
haven't even
gentlemen. We'll
honored-
have to
you haven't even
clear
done
the
that.
courtroom.
I don't agree to a stop when I move this court for a motion to dismiss.
The record should reflect
The record should reflect that my rights are being trampled on. The record should reflect that I don't agree to a estoppel.
Yeah. So I think this is actually an earlier incident here.
I provided you yesterday as a courtesy with a copy of my
I think this is at the very beginning. This is the earlier this morning. This was going on all day today.
oaths of office. My name is on that as well.
They were not certified.
You are
Your Honor.
attempting to disrupt with asking questions like this.
I am not
I
attempting
realize
to
it may very well be related to your claim to be a sovereign citizen and
Claim to be
disputing
sovereign.
the
Claim to be sovereign, let's correct the record right
jurisdiction
now
of this
while we're on
court,
the
but
record.
these are not questions this court is obligated to
I would like to
answer.
correct the record and say that I am sovereign.
All right, you believe you're sovereign, the record is corrected. So, Mr. Brooks, we're getting really close for you crossing the line,
Really close to crossing the
being
flat line,
removed
Your
from the
Honor.
courtroom for
I
continued
do not-
interruptions.
I do not
want you
consent to
here.
that, Your Honor.
Mr. Brooks, you haven't let me get in one sentence this morning.
I haven't.
It is only, it's 8:57.
Damn.
I want you to be here. Certainly my preference is for you to be here to participate fully, but you do not have the right to disrupt the proper administration. I demand dignity, order, and decorum. You have been provided with the copy of SCR Chapter 62 that lists the responsibilities that myself, the attorneys in this courtroom, the litigants, it even applies, as you can see if you read it, applies to witnesses, jurors, those in attendance. Everyone here has been respectful other than you throughout these proceedings.
I object to that respectfully. I have not been disruptive, and I do not see any paperwork that you just described to be in front
Mr.
of me.
Brooks,
Your
I'm
Honor.
going to continue with a finding right now that you have flagrantly disregarded elementary standards of proper conduct. That conduct will not be tolerated. You stating things even in a mild-mannered tone of voice doesn't change the fact that we've had a dozen or more interruptions by you and by you alone. When you don't like the answer I give, even if that's a non-response, you continue to ask the same question over and over. You repeat yourself. You show absolutely no respect for the court, for these proceedings. You have demonstrated in the short, not even 30 minutes that we've been on the record, that you will continue to disrupt. I am going to have the jurors brought in. Again, it is my sincere hope that you follow these simple and basic rules, but the next interruption, you will be removed to the next courtroom.
I do not consent to any paperwork that is not based factually in law. I don't give my consent,
We have the jurors here?
and I will not agree to anything.
Not yet, okay.
So again,
Your Honor, just from the
with that title, I object respectfully. With that title name that is on your card, since you will not answer the question that I've merely asked of Your Honor numerous times at this point, can that title name please direct the prosecutor to answer whether there are any more charges? Can the title name please direct the prosecutor to answer whether there are assessment for the charges
Mr. Brooks.
in her possession?
No one's going to be answering these questions, okay? I'm not requiring the state to do that.
Thank you for
I'm
subscribing.
advising you to stop asking those questions.
request
It will be
that-
considered he's interrupted.
I
Take him to the
request
next
the title
courtroom.
name.
I'll make more findings when he is in the courtroom next door, and I can do that without an interruption.
I do not consent or agree to an estoppel, and I will move the court again.
Currently, you are not muted. All right, Mr. Brooks? All right, you can mute him. All right, Mr. Brooks, you have been muted so that I can make some appropriate findings here this morning. I understand that you object. Your objection is noted. Your lack of consent.
Thank you, Deacon, for the $5.
Is noted. As I indicated earlier, I lost track after about a dozen or so interruptions by Mr. Brooks. He continues to ask questions that I told him I would not answer. And even though I made a decision not to answer questions, he keeps asking those. From my perspective, they are questions that any sovereign or sovereign citizen tends to ask regarding my name, my oath, jurisdiction, things of that nature. This court, of course, has authority from the Constitution of the state of Wisconsin, the statutes. I've been duly elected twice now by the citizens of Waukesha County to preside over criminal and other cases in the courts of Waukesha County. I fully am aware that Mr. Brooks, as a sovereign, disputes the validity of that, but from my perspective, they are not issues that need to be debated. He raises these issues really just by simple statements. He has never filed an appropriate motion. Motions are governed by state law. Written motions require that the specific relief be requested, that the motion be based on law and fact. I've never gotten anything even close to that from Mr. Brooks. Even if I were to accept an oral motion, which can be proper at times, he has failed to follow the simplest of procedural requirements. He continues to be in the other courtroom. You can see on the monitor, he's standing, he's facing the other direction, he's yelling.
Debbie.
What?
Hey, I don't know what I'm doing on this. I should probably turn on a light.
Hello, Debbie.
I can't see myself. I can't see you. What am I doing?
I am sharing the screen. Oh wait, am I not? No, I'm not sharing the screen. Hang on. There we go. Now I'm sharing my screen.
Oh my gosh, I'm on my phone. Maybe that's part of the problem. No idea what I'm doing.
But everybody can hear you. The whole chat can hear you, though. So,
Oh,
I mean, at
hey,
very
chat.
least, that's good.
What's up?
So you should be seeing Judge Darrell if you click on what I'm sharing right now.
I'm clicking on. What is this platform? Mandy,
I'm
help.
one of the only. I feel like I'm one of like a handful of attorneys who use Discord, or at least law tubers, I should say.
Well, like, can you see me? Like, what am I doing?
I can see you. I can see your presence in the channel, and I can see you talking, right?
Okay. So it's not a video. I'm just figuring out what I'm doing.
Your
here.
video, no, we don't see your video. You have to do that yourself.
Gotcha. Well, this is fun. So what have you covered so far?
Well, we're about to finish up the last bit. We got about 7 more minutes left in this particular video, highlighting day 2 of jury selection with Mr. Brooks. He's basically been completely disruptive and not really participating at all with the proceedings other than to be disruptive. So
Oh, well, that's really helpful to the legal process, isn't it?
naturally. So the main reason why I wanted to have this stream is because I know a lot of folks in chat and have been asking me, why on God's green earth did the judge allow him to represent himself in the first place? Because though, hindsight's 2020, we all know how these guys operate and how they're going to act. So why allow this initially? And I kind of went and gotten through a little bit of background legal research in the 7th Circuit on self-representation and the right to counsel, and kind of talk about the little balancing test that the judge has to do when it comes to that.
And he hasn't been deemed incompetent, obviously,
No.
right? Did they do a competency eval on him?
I think, if I can recall the initial hearing of when she did the Ferretta, they didn't mention that he initially, I can't remember if he was found competent or they didn't do a competency hearing. I don't remember. I think they did. And they found him competent, at least to stand trial.
Well, and I mean, competency doesn't mean that you're intelligent legally on the issues and procedures, unfortunately.
Right, but based on what I've been able to find, the courts tend to distinguish between the ability to, uh, be to determine competency to stand trial and competency to represent yourself. And I think one of the cases I was going to highlight or mention did point out that the competency to uh self-representation isn't necessarily the competency to defend yourself, more so the competency to knowingly and voluntarily waive your right to counsel.
Well,
Which
and I mean, it just, I think what he has standby counsel, right?
not in Wisconsin, they don't allow that.
Really?
Yeah, I was surprised too.
Because it would seem like to avoid appeals and having to do this whole, whole thing again, they'd at least appoint some standby counsel.
Yeah, no, he's not does not have standby counsel, but the way I understand it, I think, I guess we're kind of jumping the gun here. The way I've understand it from the cases, and I'll probably go into the case a little bit more in depth, is it's generally because of these are competing rights to self-representation and right to counsel. It's more preferable to show that the defendant was able to exercise his right of right of self-representation, rather than to abscond on that and say no, you need an attorney. Based on this, the Seventh Circuit I've read, the court says that you need to ensure that right of self-representation has been protected. And in the particular case that I found, the court, based on some of the limited trial transcript input that they put in the opinion, the court definitely jumped the gun, in my opinion, in terms of denying his right to go forward pro se. And the court explicitly said, and I think this is actually a direct quote from the court. What was it? In the last bit. Where was it? Here. The trial court would have been on solid constitutional ground had it allowed Washington, the defendant, to waive his right to counsel, then terminated his self-representation if it became clear that Washington was mentally unfit to conduct trial proceedings, or that he sought to, quote, use the courtroom for deliberate disruption of his trial, end quote. So I think that's the angle that the judge is going here, is that to ensure that this thing doesn't get overturned on appeal, she's going to let him ride for, a week, whatever it is, and then build the record large enough so that when she ultimately revokes his right of self-representation, she won't be overturned.
Well, I mean, I guess dot your I's and cross your T's, right?
Yeah. I especially when it comes to this particular case. This is a guy who, ran over, killed 6 people and injured 60 plus more last year. And I think the last thing the judge would ever want is for a mistrial to happen or for this to be overturned on appeal.
Right.
And have to do this all over again. So I think she's being very cautious about, reacting to this guy's behavior and not, jumping the gun. Because I think ultimately everybody knows what the conclusion is going to be. So I think she wants to ensure that, as you mentioned, all the I's are dotted, all the T's are crossed.
Oh my goodness. Well, I can only be on for a few minutes because I promised my kids I would head home here shortly. So,
Well, go take care of your kids.
I know it's those kids. They're so demanding sometimes. They
mean,
want a certain type of juice, and
what
so
are
I'm
they
like,
even good
"Oh."
for anyway?
I know. Well,
What's the
hopefully they'll
point
take
of
care of me in
children?
my old age. That's what I'm hoping for.
Ban children. Hashtag.
Children. I mean, they are pretty sweet. My son wrote a really sweet essay for the America and Me essay competition. So I'm like, oh, hit me in the feels. He wants something. So anyway. Well, hey, thanks for inviting me on. Sorry I
course.
didn't really get to, participate
No,
much,
Well,
but
it's my fault. It was my fault. It was completely like, short notice. I sent
that's kind
in.
of how I roll though. I don't like to plan ahead too far. Just got to kind of fly by the seat of your pants.
True. But hey, I appreciate you coming in and listening in. So
Yeah, and we
absolutely.
definitely need to do like a collaboration here soon.
course.
I need to get back on the horse since Fair Week is over. Most of the animals are at their new homes or wherever. So we'll get together.
True. Definitely. I will. Absolutely.
Well, thank you.
All right. Thank you for dropping in. Take care.
No problem. See you, Artie.
Bye. Go check out Debbie. Go check out her channel. But I promise we'll get back to talking about those cases, and also another case that I think y'all will be more hopeful about too. So let's continue on.
I can't hear him, but it appears that he is yelling. I muted him because of his interruptions of the court, and I understand he objects. His objection is again once is noted. And
He's acting
because
like
of
a
the
jackass.
disruptions, and based upon the authority in Illinois versus Allen, I also referenced yesterday a persuasive case. It's not at my fingertips. I'll get that for the record. It's the Pennsylvania case that I found to be of persuasive value, where a similar procedure was done. Frankly, what we are providing here in Waukesha County through the use of the technology we have in the courtroom is far superior to what was done in that Pennsylvania case. I have the ability to mute, to unmute. I can see him. He can see the 4 cameras in this courtroom right now. That would be me. It would be the table where I would like him to be seated. That is empty, the prosecution table, and then the witness stand. I am cognizant that the one limitation is the cameras do not pick up the jurors when they sit. There may be, depending on the angle on the witness stand, a few jurors that would get captured, but of course he cannot see those. He's able to hear them, of course. I will instruct the bailiffs over there to give him a pad of paper if he doesn't have one already. I know he had some documents and some things in front of him. At one point, I saw him sort of do a sweeping motion, and things seemed to go flying. I'll get some verification of that from the bailiffs who are over there through the bailiff that is in my courtroom. But he will at least be given a notepad, a writing utensil. He is advised that should he want to raise a strike for cause of any juror, my procedure is to address that at the end. Certainly if something comes up before that and he wishes to do that under the law, he can simply write on the pad of paper he has cause, hold it up, and I'll make a determination if I should excuse the jury and then take up that decision. I'm probably not going to do that with frequency. He would need to further not only do that, but write on a piece of paper the juror number, the basis for that request before I would require the jurors to be excused to take it up.
So what she's doing is describing on the record the procedure going forward while he's in the other courtroom. Because again, she does not want this to be overturned, and she does not want this to turn into a mistrial. She wants to ensure that despite him being a complete asshole and a complete jackass in the courtroom, that his rights are maintained, and so that that she has an airtight case, or the state has an airtight case to prevent this from being overturned. So that's why she's going through all this mundane stuff to by letting her know that this is how he can notify the court about a juror. He has plenty of pens, plenty of papers, plenty of notepads so he can write notes, so that he has everything that he is entitled to have during these proceedings.
But that's the procedure that this court will follow. Just like I did yesterday, after I get through all of the questions, I will ask the parties if there is a request for any individual questioning of jurors, meaning outside the presence of other jurors. I would need to know, again, what juror number, what question. They need to be questioned about, whether that be a numbered question from the questionnaire or a question that was asked in court. Parties will also be given an opportunity to ask appropriate follow-up questions. Once that opportunity is concluded, I then have a few concluding questions, and then ultimately will excuse the jurors to take up the issue of strikes for cause. I've been advised that Mr. Brooks did throw some items on the floor, but he does have his paperwork and a pen.
Your Honor?
Go ahead.
I just want to make sure that we put on the record that it has been verified that Mr. Brooks can hear this court.
We'll do that, yeah.
Also that I believe I had heard that the juror questionnaires for the next set of jurors coming in have been provided to Mr. Brooks.
Thank you for that reminder. He has been provided with 2 additional binders. He probably doesn't even have the first one anymore because the first binder only went to juror number 41. He does? He still has it? Okay, so he has that binder. He has 2 additional binders, which are separated. I believe it's 42 to 70 and then 71 to 100 something. But it is the balance of the jurors who had been instructed to come on day 1. This is the jurors who were not questioned yesterday. It's not even all of them who will be coming in because of the physical limitations in this courtroom. We'll bring in 41. So he has been provided with those binders. Were we able to verify? We were able to verify the audio is working. The video is working, just like we can see him, he can see us. For those of you who are in the courtroom, what he would be seeing on the monitors would be that 4 square as well. Because it is through the Zoom, he would have his picture as well. So he would see the double image, if you will. I should also make a record that there are a number of individuals on my Zoom as well. There was a request by the state to allow victims under the statute and Constitution to be present by Zoom for jury selection due to the court not streaming jury selection. I believe I also have Attorney Anna Keys also watching as well, along with at least one actually I think I see 2 victim witness workers. So I have a lot of screens up here, a lot of boxes on my screen. So I believe the state has complied with victim rights. Would you please confirm that?
We have.
Did I overlook anything you asked me to cover?
Your Honor, the only other thing, and I think the court somewhat made a record by your findings, but I know that the defendant made 2 motions to dismiss for judicial misconduct. Again, I'd ask the court to summarily deny those motions based upon.
Okay, so he did file, actually, I think I missed this part. He did file 2 motions to dismiss for judicial misconduct, because of course he did.
Lack of merit, and he didn't provide any support for either motion.
I believe he did raise a motion to dismiss based on judicial misconduct. I think he also threw in there another request to stay the proceedings or file an interlocutory appeal. While that's really not something I would need to address because nothing's been filed as it relates to a request for an appeal, I will deny that summarily. There's been no basis in law or fact provided. I'll also deny the motion to dismiss based on judicial conduct, based upon there being no showing in law or fact. All right, anything else then before the jurors are brought in?
No, Your Honor, thank you.
I will, just like I did yesterday, advise the jurors that Mr. Brooks is appearing from a remote location, and that should not influence their verdict in any way. It appears to me that Mr. Brooks continues to stand, make hand gestures, and talk. I will, again, just advise him, should he desire to raise any issues with the court, he is advised to write that down on paper. The bailiffs are instructed to promptly provide that either to the court staff that's in there or another bailiff, and that will be provided to me forthwith so that I can raise any issues of merit. All right, with that, then we will begin the jury selection process, and so we can go ahead and bring them in.
So that's I think that's, oh wait, we have one last one. My bad. Here we go.
This time I have my phone so I can call Darlene and have her let my pups out. It was a fatal mistake. I know, which I couldn't contact her to say it's going because I forgot my phone upstairs.
So the judge would like you to cross off any people that are already named in number 8.
Oh, yeah.
Okay, that won't take. And then anyone you, she's talking to Captain. Okay. And then anyone.
Guys, if you're having issues, please refresh. Comcast is Comcasting me.
You know you're not going to call. Okay. Okay. And then she is going to do that.
Okay. Oh, perfect.
But I should do your hair. Okay.
All right, we are back on the record. Mr. Brooks, I was able to inquire. I've been told it would take maybe 15 minutes, but I'd like you to go to your cell to get whatever.
Oh, God damn it, we did play this one. My bad. Sorry. Ah, this is it.
This is ridiculous, man.
It's short one, but the the prick is like complaining about how ridiculous this whole thing is, about how his rights are being violated.
Soon as I raise the issue, I'm being disruptive. I'm intentionally trying to be disruptive. I'm intentionally doing this. I'm intentionally doing that. So I should have just stayed over here, which ain't even legal to do anyway. Can't be present and not present when it should be a motion. This is ridiculous, man. This is ridiculous.
Okay.
You're forcing somebody to agree to something that they ain't agree to. Y'all come up with anything y'all can. Anything y'all can, huh? Why I need that in here? You could have left that over there. I'm going back over here anyway.
Just in case.
If I'm right here in front of her face, I don't have no problem hearing it.
Good.
That's why these could have, I'm gonna have to go back over there. Y'all know that.
We'll bring it with us if you
I'm just saying, man, this is ridiculous, man. This is ridiculous.
Honestly, with the way he talks, you would think that this was like a goddamn traffic case and not a case where he murdered 6 people and injured 60 plus more. That's what kind of gets me agitated. So we're going to talk about, we're going to close up with talking about another case. I gave you guys the case where I believe the judge probably relied on, or at least looked to in terms of whether, or in terms of granting his right to self-representation. But I want to show that this case, this is United States versus Brock, that although it's a federal case, it is a case in the 7th Circuit. But this one actually, I didn't even know this until I found this case when I was doing my research, is that this is a this guy is the defendant is also a sovereign citizen. The opinion doesn't explicitly say that he's a sovereign citizen, but you could tell by his filings that that's exactly what he is. So so he was charged with possession of a machine gun, 3 counts of possession of a machine gun, 2 counts of dealing with explosive materials. He was appointed counsel, and after Cameron had represented Brock in several pretrial matters, trouble began. On April 14th, 1997, Brock filed a pro se motion titled, quote, "Demand for Bill of Particulars," end quote. On April 24th, Brock filed a second pro se motion titled "Affidavit of Denying Entry of a Plea and Appointment of Counsel." In the second motion, Brock denied that Kamen or any other attorney was authorized to act on his behalf. The judge conducted a hearing on May 13th to determine whether Brock wished to waive his right to counsel and invoke his right to self-representation. At the hearing, he repeatedly demanded the Bill of Particulars and challenged the court's authority. B. Unsatisfied with the court's responses, Brock refused to answer the court's questions or to cooperate in any way with the proceedings. Finally, Brock stormed out of the courtroom and the court held him in contempt. On May 13th, the trial judge relieved Kamen of his appointment to representative and appointed William Marsh as standby counsel. The judge also directed a magistrate to inform him of the riskiness of self-representation. He conducted the hearings on May 14th, 15th. Brock repeated his demands and refused to answer any questions about whether he wanted to be represented by counsel. The magistrate cited Brock for contempt again. The court subsequently permitted Brock to proceed pro se, so they granted it to him. Wait, is that true, Hitchbot? Hillegas was found in Kansas, and they're currently, as of earlier today, preparing for extradition. Oh, shit! Roger Hillegas, the other sovereign citizen out of Nevada, according to Hitchbot, he's been located. Oh, that's awesome. So finally, we can have a continuation. That is awesome. I did do a breakdown of Roger Hillegas that was way back earlier this year. Thank you, Iceblade, for subscribing. Finally, so on June 6th, the court granted Brock's ability to go pro se, but on July 3rd, so about a month later, a hearing convened to reconsider Brock's pro se status. Brock continued to, quote, challenge the court's jurisdiction and made repeated demands for a bill of particulars. The court found that Brock had forfeited his right to represent himself and appointed Marsh to serve as Brock's counsel. He was tried by a jury and convicted on all 6 counts of the indictment. On April 2nd, he was sentenced to 108 months of prison, 3 months of supervised release, and $2,000 fine. He filed a timely notice of appeal. So this is this is what I think the judge in this case is kind of going for here. Implicit in a criminal defendant's Sixth Amendment right to counsel is the defendant's right to self-representation, e.g. Ferretta versus California. As the Supreme Court reasoned in Ferretta, the right to defend is given directly to the accused, for it is he who suffers the consequences if the defense fails. However, the right to self-representation is not absolute. The trial judge may terminate self-representation by a defendant who deliberately engages in serious and obstructionist misconduct. Therefore, the issue before us is whether the district court's decision to revoke Brock's pro se status was justified in light of Brock's conduct. We reviewed the court's decision for abuse of discretion. So they talk about Illinois versus Allen, which is another case that dealt with the right to self-representation. Brock's conduct made it practically impossible to proceed. Contempt citations had no effect. Despite the district court's repeated attempts to secure his compliance, Brock stubbornly adhered to his policy of insisting that the court provide a bill of particulars and state the basis for its authority. By refusing to answer the court's questions, Brock made it extremely difficult for the court to move forward with its proceedings. Given the situation, the trial judge was within her discretion in revoking Brock's pro se status. Brock argues that Feretta's language severely limits the ability of a trial judge to revoke a defendant's pro se status based on the pretrial conduct. He points out that Ferretta refers to the use of the courtroom for deliberate disruption of trials. He further notes that in the U.S. versus Fluid, the Ninth Circuit interpreted this phrase to mean that pretrial activity is relevant only if it affords a strong indication that the defendants will disrupt the proceedings in the courtroom. Brock asserts that his conduct did not indicate that he would be disruptive of a trial. Therefore, he concludes that the trial judge violated his right to self-representation. Even if we were to adopt the Ninth Circuit's interpretation of Ferretta, Brock loses. Brock's behavior, unlike that of the defendants in Fluid, was sufficient to allow the district judge to conclude that there was a strong indication that Brock would continue to be disruptive at trial. In Fluid, the defendants were denied permission to travel to a warehouse. Hold on. Here we go. They kind of talk about Fluid and the Ninth Circuit to distinguish it. But in contrast, Brock's steadfast refusal to answer the court's questions made it extremely difficult for the court to resolve threshold issues, such as whether the defendant would be represented by counsel. Brock did not simply refuse to prepare for trial. He refused to cooperate, even minimally, with the court. Furthermore, Brock's obstructionist conduct persisted even after several contempt citations. It was therefore reasonable for the court to conclude that Brock's behavior strongly indicated that he would continue to be disruptive at trial. So ultimately, this is what they're going for. That the judge is going for. She wants to build the case that if she elects to revoke his right of self-representation, that there's enough placed on the record to support that finding. Did I say Ninth Circuit? If I said Ninth Circuit, I meant circuit, for God's sake. So that's what the judge, I think, is going for here. I understand. Even I look at it like this guy's making a mockery of the system. All of us who know sovereign citizens know what he's doing. We're well aware of the game he's playing. It sounds like the judge knows what he's playing, because I think that the judge, I don't think she stated it outright, but it heavily implied that she's well aware of what sovereign citizens are, what they do. But I think she, knowing that the knowing the severity of what these charges are, the events that took place, she wants to make sure that there is no chance that he's going to succeed on appeal. Because by doing that, it'll force a retrial and force the victims and the witnesses to relive this event again, yet again. Never mind the taxpayer money that would have to be incurred in retrying this thing again. But more so than anything else, she doesn't want to put the victims of this through it all over again. And so that's why she's giving him enough rope to ultimately be able to comfortably say, you've had your chance, you lost it, and now we're going to proceed forward with you with counsel. Because it's not enough. Because again, not everybody sees what we see. An appellate court is not going to see the same thing that we see. An appellate court is going to see a transcript, and they're going to see the evidence on record. I don't know if the appellate courts are going to see the video, right? If they're going to see all the different things that we're seeing. And also, again, they may not know about sovereign citizens and how they operate. So I think she wants to make sure that there's enough there. So anyway, I'm going to stop repeating myself over and over again. But I'm going to go through. I missed some of the super chats here, or at least a little bit super chats. How many? But thank you. I've missed this one. Dwarf of the House of Torg, $5 Australian. How many different lawsuits can Chile bring against Gabe to the court and stop letting him do it? It depends. If it's, I believe, if the case in question has been stopped, and if he does it more than enough, he could be labeled a vexatious litigant, and he could be fined if he keeps on doing that. Uh-oh. That's gonna go off for a while now. Shit. But thank you all for re-upping your re-upping your memberships. As always, it's appreciated. I think I'm gonna go ahead and stop here. But thank you guys again for sticking with me. Thank you all for hanging out, and I wanted to keep it, I want to keep these streams like short and concise and not being a jackass towards the tail end. But thank you guys again for watching. As always, thank you for all the likes and all of the subs. Please join my Discord if you haven't already. And I want to, I don't know if I'm streaming tomorrow. The trial might actually begin tomorrow, so if it does, I'll probably be covering that towards the tail end. Sean Galloway, thank you for the $4.99. Already, trans girl asked if the jury will be instructed to ignore his behavior. Once the jury's been impaneled, they can make any sort of determination that they want. If he decides to be an ass clown after the jury's been impaneled, that's on him. The judge is doing everything she can to prevent, a jury from being biased going into it. But once the jury's been impaneled and he decides to be that disruptive in the middle of court, that's all on him. The judge can't prevent that from happening. So, thank you guys again. Have a good one. And take care.
everybody's waiting for the next surprise. Skeleton Jack might catch you in the back and scream like a banshee, make you jump out of your skin. This is Halloween, everybody scream. Could you please make way for a very special guy? Our man Jack is king of the pumpkin patch. Everyone hail to the pumpkin king now.